You believe you have the best personal injury or medical malpractice case around. What are the 2 times that you should be worried about you losing your case? Would you like to know the answer? Come join me for a walk in the neighborhood as I'm heading to the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The first time you should be worried about not being successful in your case is after all discovery has been completed, after everything is ready, and now your attorney tells the court that your case is ready for trial, and the defense tries to get your case thrown out and dismissed before you ever get to trial. That's known as a motion for summary judgment. And you might be thinking, what's the big deal? Someone's trying to get the case thrown out. You know you have a great case. You have great experts. You have great testimony. Your attorney believes you have a great case. There's no possible way the judge is ever going to throw your case out. That would be incorrect thinking. That is number one. That is the number one time you should be concerned. Why? Because if the defense is going ahead and trying to get your case thrown out, they believe that they have sufficient evidence and sufficient proof to get your case knocked out before you ever get to trial. What's the second time? What is the second time that you should be concerned that you may not be successful in your case? The second time is now after 2 or 3 hard years of hard-fought litigation. Now your case goes to trial. You have spent weeks on trial putting in your evidence and the testimony and all the proof necessary to establish that you are slightly more likely right than wrong, that what you are claiming is true. Now, after all of that testimony has occurred, after the judge has given his legal instructions, after the attorneys have given their closing arguments, and now 6 members of the community, people who you do not know, strangers, are going to decide whether you and your proof and your evidence are slightly more likely right than wrong, that what you are claiming is true. If the answer is yes, then you will be successful in some fashion. However, there is the risk that now a jury determines they don't like your case. They may not like you. They may not like the credibility of your witnesses. And guess what? You run the risk of losing your case after all of these years of litigation. Why? Because that's an unknown. You go to trial, you have no idea what's ultimately going to happen, even if you believe you have the best case ever, even if you believe you have the best witnesses, even if you have great experts. There is no possible way to know going into a trial what your ultimate outcome will be until the jury comes back with their verdict, and now the judge turns to them and says, ladies and gentlemen, what is your verdict? Was the doctor careless? Yes or no? If the answer is no, your case is done, it's finished, and now you go home without a dime. If the jury turns around and says, yes, the doctor was careless, now the jury has to answer the next question. Was that carelessness a cause of your injury? Was there a causal connection? If there is, great. Now you move on to the next question because you're not successful yet. However, if the jury determined that yes, your doctor was careless, but his wrongdoing, his carelessness was not a cause of your injuries, guess what? You lose and you get absolutely nothing. So that is another instance when you should be concerned about whether or not you're going to be successful. So what happens then? What happens if the jury comes back and says, yes, the doctor was careless, and yes, his carelessness was a cause of your injury? Guess what? Then the jury will have to decide how much money you are to receive as full and fair compensation for all of the harms and losses and damages that you incurred because of this person's carelessness. Now, you may be going into your trial thinking that your case is worth millions and millions of dollars. And you know what? It just might be. However, the jury may not see it your way. The jury may decide that your injuries are worth only a small fraction of what it is that you and your attorney are asking for. On the other hand, the jury could come back and give you exactly what you and your attorney are asking for, or alternatively, they could give you substantially more. It is an unknown. So that is another instance when you should be concerned about what's ultimately going to happen in your particular case. So just because you believe you have the best case ever and all the proof reflect that you have a fantastic case, you should be concerned during those 2 instances during the course of your litigation. 1, when the defense makes a motion for summary judgment, and 2, when you go to trial And now you're waiting for the jury verdict to come back, and you're sitting on pins and needles saying, when are they coming back? Why are they taking so long? What could they possibly be thinking? It's so clear cut. I don't understand why they're sitting around for hours and hours debating this. It should be so simple. They should give us a verdict in our favor, give us exactly what we're asking for, and then move on. So why do I share this quick information with you? I share it with you to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.